Welcome aboard, applicants. Let's begin with question 2 from the first year law students exam, June 2016. And remember, as with all essay questions, we begin with the call of the question. Let's begin. Number 1, can Bill prevail in his lawsuit? Discuss. 2, if so, what damages, if any, is Bill entitled to recover? Discuss. Well, we don't know if this is contract law or tort law yet, so we may have to read our question to be able to get that area of law question answered. Okay, so let's do that. First read. Sarah is a doctor who collects, buys, sells, and trades baseball cards for profit, averaging 15 transactions a week. She is a recognized expert in the 1939-1950 era. Bill operates a store that regularly sells baseball cards. Bill claims he phoned Sarah and offered to buy a 1939 Denny Wilson card for $550 and that Sarah accepted. So let's stop right here. We know that offered is a contract term. We can actually now begin understanding that this question is about contract law. So let's come back now to our call and begin answering our call. Now, down here, addressing call number 1, can Bill prevail in his lawsuit? Now, who is Bill suing? I guess I needed to read a little bit more, so let's read a little bit more. Now, immediately after the telephone conversation, Bill sent Sarah an unsigned typed letter confirming the contract and identifying the parties, the Denny Wilson card, and the price. Bill's letter had a letterhead identifying the name of his business. Buyers, baseball cards and collectibles. The letter included the following term: seller shall provide a certificate of authenticity from the Baseball Trading Cards Association. Certificates of authenticity cost $100 and significantly increase a card's value. Sarah's card was not certified and the parties had not discussed this before. Sarah received and read the letter but did not respond to it. When Bill called later, Sarah said she had sold the card to another party for $575. Bill sued Sarah for breach of contract. Right here. Here we go. Highlight this. But we're going to continue reading though, even though we have who Bill's lawsuit was against. Seeking $250 in damages based on $800 as the fair market value of a certified card. Sarah denies the existence of a contract, alleging that Bill only asked, would you consider taking $550 for the card, and that she replied, okay, send me something in writing. Alternatively, she claims that the phone agreement was unenforceable and that the so-called letter of confirmation had no legal effect. She also contests Bill's calculation of damages. Okay, so now we know, can Bill prevail in his lawsuit? So it's basically going to be Bill v. Sarah. Okay, and that down here for call number 2, we're going to say, if so, what damages, if any, is Bill entitled to? We'll say damages Bill is entitled to recover, question mark. Okay, now that would probably be an excellent way to start out now. And now that we know our area of law is contract law, let's throw down our shopping list. Okay, contract formation, third-party rights, covenants, conditions, excuses, discharge of duty, breach of contract, and remedies. Okay, now that we know damages aspect concerns remedies, we will peel this off of this and put this down here. Okay, excellent. Okay, very well done. Okay, now let's come back up here and begin our second read involving our issue spotting skills. Okay, now Sarah is a doctor who collects, buys, sells, and trades baseball cards for profit, averaging 15 transactions a week. She is a recognized expert in the 1950 era. This is foundational facts, supporting facts for something that might be an issue just ahead in another paragraph. Okay. Now, Bill operates a store that regularly sells baseball cards. Okay, still supporting facts. Bill claims he phoned Sarah and offered to buy a 1930. Okay, right here. Now, before we even get into this aspect, we know now kind of the direction that these facts up here are leaning in, and this would be for applicable law. And what are we dealing with here? Now, Bill claims he phoned Sarah and offered to buy a 1939 Denny Wilson card. Okay, now under the 1939 Denny Wilson card for $550, and that Sarah accepted. So we're dealing with a 1939 Denny Wilson card. Is that a good or a service? That looks like a good to me. So the Uniform Commercial Code looks like our applicable law. And we want to make sure to put this. This is the Denny Wilson card. Okay, perfect. Oh, make sure I'm spelling that right. Denny Wilson. Yeah. Okay. Now, because we're dealing with the Uniform Commercial Code, we also have the added topic or the added issue of merchant status. Now, would Sarah be considered a merchant? Now we see where this paragraph goes. Sarah is a doctor who collects, buys, sells, and trades baseball cards for profit, averaging 15 transactions a week. And to even add to that, she is a recognized expert in the 1939 era, all right, 1939-1950 era. Now, what is it we're dealing with here? A baseball card, a 1939 Denny Wilson card. Now, because she buys, sells, and trades baseball cards for profit, averaging 15 transactions a week, and she's adding that to this aspect that she's a recognized expert. So I want to pull this out of here. Recognized expert. She averages 15 transactions a week in baseball cards and is an expert in 1939 to 1950 era, which is exactly what we're dealing with here, 1939 Denny Wilson card. I would say that Sarah qualifies as a merchant because she regularly deals in the goods and the kind involved in the contract, a Denny Wilson 1939 Denny Wilson card, or she has special skill or knowledge related to said goods, which would be the 1939 Denny Wilson baseball cards. Absolutely. Okay, so I would say here I'd add that Sarah equals a merchant. Now let's ask ourselves here, is Bill a merchant? Well, Bill operates a store that regularly sells baseball cards. Absolutely. He would be considered a merchant because he regularly deals in baseball cards. So they're both considered merchants and held to a higher standard of good faith and fair dealing and commercial reasonableness. Okay, now down here under contract formation. Okay, remember a valid enforceable contract contains valid or an enforceable offer, acceptance, consideration without applicable defenses to contract formation. So now under offer is a present manifestation of intent to be bound, communicated to an identified offeree, implying that offeree to accept the offer. Now, what is it we have here in terms of our terms from our terms from the claim that Bill makes that he actually offered Sarah, okay, concerning their telephone call. Okay, now, he claims in this sentence here that he telephoned Sarah and offered to buy a 1939 Denny Wilson card for $550 and that Sarah accepted. So we're looking at this much here in terms of our offer aspect. So let's stack our issues right here. Quantity, time for performance, interested parties, and price, and subject matter. So quantity, we already know that. It's one Denny Wilson 1939 baseball card. Or I should say card, just to be more exact. And then time for performance, reasonable time. Excuse me. Interested parties would be Bill and Sarah. Price $550. Subject matter 1939 Denny Wilson card. Okay, now it looks like we have sufficient terms, and specifically speaking, we have the quantity term, the price term, and the party term, certain and definite. So it looks like we have a valid offer coming from Bill to Sarah. Now, the question then is Bill correct by saying that Sarah accepted? Now, down here, we have a paragraph that says that she declines the existence of a contract and alleged that Bill only asked, would you consider taking $550 for the card? And that she replied, okay, send me something in writing. Now, alternatively, she claims that the phone agreement was unenforceable and that the so-called letter of confirmation had no legal effect. We'll get that letter of confirmation here in a minute. She also contests Bill's calculation of damages, which we'll also get here in a minute. But she denies the existence of a contract, alleging that Bill only asked her, would you consider taking? Now, down here, we're going to throw in acceptance. Remember, acceptance is an unequivocal assent to the terms of the offer in the means or modes invited by the offer because the offeror is master of the offer. Okay, now we're going to look at it from Bill's perspective first. He says that Sarah accepted. Immediately after the phone conversation, then Bill sent Sarah an unsigned. Now this is typed letter confirming the contract. We will take that up here in just a minute. But he's going to say that Sarah accepted. So from Bill's perspective, so we're going to write. Bill's argument would be that there was an acceptance by Sarah. Okay. Now, should say probably I should say probably just acceptance here, and we'll put this in parentheses like over here, Bill's argument. Now, what is it that Sarah is going to possibly counter argue here? She's going to say, would you consider taking $550 for the card? And then she replied, okay, send me something in writing, which is what? Not an agreement, but possibly maybe a rejection. So a rejection by Sarah, which is what Sarah's going to argue. Now remember, this is a way too that the not necessarily the offer can be terminated, but because we're dealing with a face-to-face agreement, that might be a way to argue it. But if indeed we're the face-to-face agreement, oh yeah, you know what? That's exactly right. Now that I think about it again, in a face-to-face agreement, if the parties have not reached a mutual assent, basically an offer and acceptance, then that offer would terminate. So that's technically what she's also arguing, not only a rejection by Sarah, but a termination as well. So I want to put that in there. So here, okay, let me add that right after rejection here. Okay. Which is Sarah's argument. Okay. But assuming that there is an acceptance, then we would continue now. But right after acceptance, before consideration, we have this aspect, this paragraph here. Immediately after their phone conversation, Bill sent Sarah an unsigned typed letter confirming the contract, and identifying the parties, the Denny Wilson card, and the price. Bill's letter had identifying the name of his business, buyers, baseball cards, and collectibles. The letter included the following term: seller shall provide a certificate of authenticity. Now, here we go. Now, was this in the original agreement? Was this an added term, or was this a conflicting term? This looks to me like it's an added term because it wasn't in the original offer. The original offer was a telephone that Bill claims is a telephone conversation considered a face-to-face conversation. Yes, it is. Absolutely. because that's exactly what Sarah is arguing, is that there was no agreement. All she was arguing is, or finding I should say, is that she was telling Bill that she said, okay, please send me something in writing. So she's not only rejecting the offer, because she rejected the offer and Bill followed up. Now here's the thing though, the argument for the termination is, if you follow up on that, does that actually terminate? Because remember, words to the contrary can still keep that offer open. But were there any words to the contrary, that it would otherwise, instead of the offer terminating, the offer would exist for a reasonable period of time to what? To allow Bill to send Sarah something in writing concerning the offer of the 1939 Denny Wilson card for $550. That's a, it's a argument we could make. Now, but back to our seller shall provide a certificate of authenticity from the Baseball Cards Association, which is an additional term I'm seeing. This, now remember, certificates of authenticity cost $100 and significantly increase a card's value. Now, Sarah's card, though, was not certified, and the parties had not discussed this before. So they're making this very clear for us. This was an additional term. So let's put that down there. And what UCC statute should we immediately be thinking? Uniform Commercial Code 2-207. Additional terms. Okay, now this yeah, exactly. And this would be the certificate of authenticity right here. Certificate of authenticity. All right, here, I'll add that in here. Okay. Now, remember, between two merchants, the additional term would become part of the contract unless, one, the offer expressly excludes any additional terms coming in, which we don't see that here. Number two, the additional term would materially alter the agreement. Possibly, we could argue that. And number three, the other party, which would be Sarah, did not object to it within a reasonable period of time. Now, if neither one of those three takes place, then that term becomes part of the contract. Okay, that additional term becomes part of the contract. Do we see Sarah objecting to this? Now, Sarah received the letter, or received and read the letter, but did not respond to it. So that's our first aspect. She did not respond to it. So there's no objection within a reasonable time. But now we got to ask ourselves here: does this additional term materially alter our agreement? Absolutely, it does. By what? A cost of $100. Yeah, and when we're dealing with a $550 original contract price, that could be seen as materially altering our agreement. Now, and also we added this thing: significantly increase a card's value. Okay, so I would say, you could argue that it may not become part of the agreement. But you could also argue, too, that it could become part of the agreement. And we'll see how each of those arguments take shape when we get to remedies. Okay, now, we make sure now, after the UCC 2-207 additional terms is talked about concerning the certificate of authenticity, we throw in a consideration to argument, okay, which is money exchanged for the Denny Wilson card. Denny Wilson card in exchange for money. So sufficient consideration. And then we have the statute of frauds argument. Now, remember, this is when we're dealing with goods $500 or more. Okay, now, do we have a contract concerning the sale of goods $500 or more? Absolutely. The Denny Wilson card for $550. At least $550. Now, if the additional term becomes part of the contract, that may be kicked up even to $650. But assuming that we just stick with the $550 right now, that would even trigger the statute of frauds argument. Do we have an exception? In other words, do we need a writing? Absolutely. Do we need a signature of the party to be charged? Absolutely. Do we have it though? Let's look into our question here, the facts of our question. Now, immediately after their telephone conversation, Bill sent Sarah an unsigned typed letter confirming the contract, identifying the parties, the Denny Wilson card, and the price. So we have a writing, but do we have the signature of Bill here? Remember, ours is. Do we need a signature of Sarah, or do we need a signature of Bill? We need a signature of Sarah because Sarah is the party to be charged, the one being sued here. So do we actually have a signature by Sarah here? No, even Bill's letterhead, even the letter that had a letterhead identifying the name of Bill's business, Buyers Baseball Cards, would not suffice for a needed signature of Sarah. So we need an exception to the statute of frauds defense barring our enforcement of the agreement. And what would that be? Absolutely, the merchant's confirmatory memorandum. Now remember, do we have a writing here? Yes. Is there a signature of a merchant? Absolutely. Bill. How do we know? How do we know we have Bill's signature? Remember, it says he didn't sign it, but remember what could substitute for a consideration? A letterhead identifying the name of his business. That would suffice for a signature. Does it contain all the necessary terms? Absolutely. It confirmed the contract and identifying the parties in the Denny Wilson card and the price. All necessary terms. Now, again, the only way that this wouldn't work is if Sarah objected to this confirmatory memorandum within 10 days. Does she object to it? Here's these facts again. Sarah received and read the letter but did not respond to it. There we go. No objection. So the merchant's confirmatory memorandum would indeed become part, or would indeed allow us an exception to the defense of statute of frauds. Okay. Excellent. Alrighty. And we don't have any third-party rights here. Okay, good. Now, after we've gone through here in terms of our contract formation stage, do we have any conditions, covenants, or excuses argument? Now remember, you could always throw in constructive, or I could say the implied obligation of good faith and fair dealing, because that's actually implied in every agreement. Now, we could also say under the implied obligation of good faith and fair dealing that Sarah and Bill should proceed under the contract in good faith and fair dealing as they agreed to within the contract. Okay. Now, with that being said, then, do we have any further conditions, covenants, or excuse arguments? I don't see that at the point in our read. Let's continue reading though. Now, Sarah received and read the letter but did not respond to it. When Bill called later, Sarah said she had sold the card to another party for $575. Now, Bill sued Sarah for breach of contract, seeking $250 in damages based on $800 as the fair market value of a certified card. Now, remember, when Bill called Sarah and she told him that she had sold the card, what could that be seen as? Absolutely. It's possibly that could be seen as an anticipatory repudiation. I would argue that. There we go. Now, after the anticipatory repudiation, we then look to the breach of contract. Remember, under the Uniform Commercial Code, how do we measure breach of contract for either in the material breach, partial breach, or minor breach? Absolutely. Perfect 10 rule. or can Bill effectively argue that Sarah perfectly tendered, or can Sarah argue that she perfectly tendered the card to Bill? Absolutely not. She sold the card to another party for $575. And so therefore, Bill will argue that she materially breached the agreement. Okay. Now, with that being said, now that we've established that there is a breach of contract claim that Bill can argue, I want to make sure to throw in a conclusion here. We come down. Now, damages Bill is entitled to recover. Remedies is our key header. Let's come down now. I want to make sure to mitigation of damages. We also look to expectation damages. Consequential damages. Hadley v. Baxendale. Okay. And then incidental damages. There we go. Perfect. And then quick conclusion. Now, under the mitigation of damages argument, Bill should mitigate the damages, or he has a duty to mitigate his damages, and he should observe that duty. Now, Sarah denies the existence of a contract, alleging that Bill only asked, "Would you consider taking $550 for the card?" and that she replied, "Okay, send me something to write." We already talked about this. Alternatively, she claimed that the phone agreement was unenforceable. We already talked about that, and that the so-called letter of confirmation had no legal effect, which is not an effective argument. Now, she also contests Bill's calculation of damages, which is what we're going to be talking to you right now. Okay, now Bill is seeking $250 in damages based on the $800 as the fair market value of a certified card. Now, remember, right down here, after the mitigation of damages, our discussion of the mitigation of damages, that he has duty to mitigate his damages reasonably, okay, and that he should do so. Now, under expectation of damages, now we ask ourselves here, what are his expectation interests? Okay, up here under the contract price, we have $550. Okay, down here, a uncertified card would be how much? Well, see, Sarah sold it for $575. We could possibly use that as a contract market differential. But he's also saying that he wants the $250 in damages based on $800 as the fair market value of a certified card. That would be a certified card that doesn't have the certificate of authenticity. So we have to say, if there's a certificate of authenticity, what would be his expectation damages, and if the certificate of authenticity was not present, what would be his damages? So we're looking here now. If no certificate of authenticity, then what would it be? Well, let's see here. We're looking at $550. We're looking at the aspect that she was able to sell it for $575. We could say that either he could possibly get, now remember, the full contract price would be $550, but what he would be able to get in the marketplace would be maybe $575. So I'm seeing possibly the contract market differential, $25. What do you guys think? Or you could also argue a cover cost as well. If he were to go into the market and buy an equivalent card, now not with no certificate of authenticity, he'd have to possibly pay $575. Why? Because we know that Sarah was able to sell the card to another party for $575. The original contract price was $550. So either way, contract market differential or the cover cost would yield a $25 damages recovery if no certificate of authenticity. And this is what we would argue is either contract, market, differential, or you could even argue cover cost. Okay, now let's ask ourselves here, if yes, certificate of authenticity, then what would Bill be entitled to recover? Let's come up here and take a look. Well, the $100 cost, that would have to be borne by Sarah. And what Bill is seeking is $250 in damages based on $800 as the fair market value of a certified card, which we know that. So he'd be arguing the difference between $800. Oh, then $250? Okay. Okay, I see what you're saying. Very, very, very well done. Exactly. They absolutely. Thank you so much for pointing that out. Very well. Very good. Okay. So, and that would be the yes certificate of authenticity would be $250. Okay. Now, under the consequential damages, if it could be argued that it was foreseeable at the end and certain at the time of contract formation that that the parties contemplated that if in the event of a breach, one of the parties would consequentially experience some kind of cost, then that might be considered consequential damages. But I don't see that here. Now, under incidental damages, those would be the costs related to the mitigation of damages. And also, I would argue that a small discussion of specific performance could be argued. Why? Because it didn't actually say unique, but a unique good. The Denny Wilson card could be considered a unique good. The 1939, and the one reason I'm pointing to that is up here. It's right here under collectible baseball. Actually, I don't think there was the word collectible up there at all. Collects, buys, sells, trades baseball cards for profit. It doesn't actually say collectible. So let's see. I don't see that anywhere either. Okay. Well, that's what I'm saying. If the 1939 Denny Wilson card is considered a unique good, then that could be argued as a specific performance. Okay. And I would put a question mark there on that. So, and then conclusion, that would be answering the damages Bill is entitled to recover. If no certificate of authenticity, I'm arguing $25 through the contract market differential or cover cost. If yes, certificate of authenticity, which has already been observed as $250 according to our facts. And if there's any consequential damages, which I don't see any, doesn't look like there were any incidental damages, but if there were, he'd be able to recover those. This one is a very brief specific performance argument, and that's it. Okay, now I wanted to put a shout out. Thank you so much for watching this with me and issue spotting this and going through this question with me. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher, and doing excellent. And I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Again, thank you so much for tuning in. There should be many more wonderful questions ahead. And again, thank you for tuning in, and God bless.